We have one case on our 130 docket. That is Sansota, is that correct?
That's correct.
Versus the Archdiocese of Denver Mortuary at St. Olivet. Counsel, have you received our oral argument instructions?
Yes, I have.
Any questions? All right. Very good. My name is Judge Dunn. I'll be presiding, and serving with me today I have two of my senior colleagues, Judge Marquez on my right, Judge Casewald on my left. Couple instructions for all of our guests today. We would ask that you turn off any electronic devices. They interfere with our recording system even when they are on silent. Also, as you probably all know, we are now live streaming oral argument, and all the arguments will be available on our website. If there is anything confidential, please conduct your argument accordingly, because once it's out, it is out there. With that, we may hear argument in Sansota.
May it please the court, my name is John R. Vranesik, registration number 6479, and I represent Teresa Sansota, Francesca Olin, and Domenico Sansota in this case. A long time ago, in the case of Jacob Ellis versus Ohio, the Supreme Court of the United States was addressing pornography under the First Amendment. And the reason I only bring this up is because the immortal words that were spoken by Justice Potter Stewart at that time. He goes, "I shall not today attempt further to define the kinds of material I understand to be embraced within that shorthand description, hardcore pornography, and perhaps I could never succeed in intelligibly doing so, but I know it when I see it." I think that's the same problem that we have in outrageous conduct. Do we really know it when we see it? And why is there such a divergence of what is and what is not outrageous conduct? There's no set formula as to what facts are going to amount to outrageous conduct, unless they're looking upon as a whole and using the same community standard that was done in Jacob Ellis and is found in Colorado, that it's within reasonable minds of the community. And we do have that gatekeeper protection under Culpeper, where the judge is supposed to look at it first before submitting to a jury. That presumes that whatever judge is reviewing that can really read the minds of the community. The facts, it's a fact-intensive situation when you plead outrageous conduct, because you can have one fact being sufficient, or you need many facts to make it rise to that level. That was argued here to the trial court, that we don't start with a body is just wrongfully put in the casket. It may have started that way, maybe that was negligence, it was a mistake, but what built upon that is what we're looking at. We're looking at that continuous course of conduct.
So, is it Vranesik?
Vranesik.
Vranesik. Is it one of your contentions that the trial court considered the pieces individually versus the totality of the circumstances with the mistaken identities?
I think the judge probably hung his hat more on intent than looking at all the facts, because the key to outrageous conduct, of course, is intent. The intent to inflict the harm, or at least having reasonable knowledge that they should have known that it was going to cause the harm, which, like in this case, I think is clearly established. If Francesca Olin has been crying for a half an hour in front of both funeral directors, they're not leading and asking them, "What are you going to do?" And he doesn't say anything to them and uses their father's body for somebody else's service. So that question is when do we transform from, quote, a mistake to an intentional tort? And that's where it's taken away from the reasonable minds of the community by the judge in this case, because the facts are not disputed, quite frankly. It's the interpretation of the facts that's disputed here. I think it's very important to note that when the court issued its order on summary judgment, he first addressed the other motion before him. And that motion, of course, was a motion to dismiss, which is now a tougher standard of plausible facts. And so he finds that we pled plausible facts. We get to the summary judgment motion, and In our opinion, we presented the substantive evidence to support those plausible facts. We didn't have to prove more, but we proved all of them. I set forth one by one by one. Defendants argue, well, it's a different standard. That's true, it is a different standard. But if those facts are supported, then they're not disputed. And it supports the finding of outrageous conduct. If they say that some of the facts are disputed, then summary judgment is improper because you have disputed issues of material fact. Now, again, in an outrageous conduct suit, you have this mixed question of fact and law as to the genuine issue. You can really get into arguing all the facts supporting the claim that you're making. But you're really looking at it, and the issue is it outrageous conduct? And so, we have that, it's kind of a wrestling between fact and law in determining, is it outrageous conduct? I think it's easier to look at it from the standpoint of how it's supposed to be resolved to resolve that conflict. And that's looking at it from the standpoint of citizens of a community, and the communities can be a national standard. Are the Coloradans entitled to less enforcement of their rights than those in Connecticut, in like the Tucillo case, or in Florida, like in the Millette case, where very similar facts are presented, and in both cases they said it's sufficient to go forward. So the problem is how do we argue with one person who's deciding that issue? Then you get back into the facts. Now we're here today de novo in front of 3 new judges. All of whom come from different backgrounds and for the first time see this case. And you're put in that same situation of how do people view these facts? How would they?
Can I ask you a question?
Yes.
Clearly, the bodies were in the wrong body was in the coffin.
Correct.
What other facts do you rely on to maintain it's outrageous? And can you start with when was the mortuary first made aware that that might not be the right body?
Okay. For definitiveness as to when they were made aware it was not the right body is when Francesca Olin gets there, goes up, and talks to Gary Lauricella and says, hey, that's my dad in the coffin. And he's calling T.J. Valero, saying, hey, we got a problem here.
How about, wasn't there an employee of the mortuary who brought it to the mortuary's attention?
What we argued was, and what they had, was a woman by the name of Diane, which we eventually found out her last name, who was the decedent's, when Sam DiCamillo was she was his caretaker, and she's the one who on 2 separate occasions went up to Gary Lauricella, one at 4 o'clock and one about 10 minutes later, 4:10, telling him that's not Sam, period.
Okay, so that happened at 4 o'clock,
Yes,
and the rosary was scheduled for 7?
7, correct.
7, okay. So 3 hours before, the mortuary was put on notice that this was the wrong body, or could be the wrong body.
Yes, and there again, that's a disputed issue of fact. I mean, I'll concede that. That evidence has to be resolved, I think, by a jury, not by a judge. But the fact of the matter is that we presented and showed the evidence, and they're admitting that, yeah, it was brought up twice. And as I said, why would she bring it up 10 minutes later after the first time, and they would still sit there and say, oh, no, embalming changes the body's looks, whatever. You tell me once, you tell me twice. It's, I think when Bush was, and I'll probably misquote it, said, well, you can fool me once, and I'm a fool, and fool me twice, and I'm a fool, or whatever.
I have a question about the record. The trial court, I think in 2 spots, references, because the mortuary immediately informed Ms. Olin and Domenico of the mistake, and here's the part I'm interested, acted in accordance with Ms. Olin's demands to not let her mother know. The defendants did not attempt to cover up the mistake. I saw no testimony that showed the defendants relied on Ms. Olin's statements. Was there any? I saw Mr. Vallaro's affidavit that said he himself made the decision with the father.
Mr. Vallaro did. But he made that decision after discussing it with Mrs. Olin, and she's saying, what are you going to do about it? And no answer. He walks away and allows the proceeding to go ahead. I look at this in the same way as the Bradbury Phillips Petroleum. You have a series of acts that not one of them is going to say it's outrageous. Where it becomes outrageous is at the end when the intent is demonstrated that a person only has to say the word stop and the harm does not occur.
So would you agree that that statement by the trial court is not supported by undisputed facts?
I'm sorry, again?
Would you agree that that statement by the trial court is not supported by undisputed facts in the record?
You know, I'm still having a hard time. I have a little hard of hearing.
The trial court's statement that I just read is not supported by undisputed facts in the record. Would you agree?
Okay, no, I lost it. I'm sorry, Your Honor.
Oh, go ahead.
No, I mean, if you can read it, I can answer the question.
The trial court seems to rely on a statement that Miss Olin, it took its actions based on statements Miss Olin made to the mortuary. I don't see any facts that support that.
No, I tend to agree with that too, because they didn't listen to her.
Okay.
And went ahead and went through the situation.
Mr. Vranesek,
Yes.
there's also a statement in the court's order that I'd like you to address. The court says no evidence has been presented that any party had additional discussions with mortuary staff or indicated their preference to stop the ceremony despite being present and aware of the plan to continue. Is there any evidence to support that your clients knew of the plan to continue?
No, none. That's why they're sitting there saying, what are you going to do about it? And Mr. Vallaro walks away, actually, centers the casket, closes it down, takes the flowers off, and they proceed with the rosary. And they are aghast because it's their father in that casket. And it's not, somebody else's religious rights were being violated at the same time as his were. The fact of the matter is that they're the ones, and I think another important fact here is the literature is that outrageous conduct arises more often in an economic relationship than not. The mortuary and its staff here were not strangers to the plaintiffs during this period of time. And their promises to respect the body, the temple of the spirit, they could care less. They were trying to save face. But we're only going to look at it from the standpoint of the plaintiffs. They're the ones who got harmed. They're the ones whose rights and feelings were totally disregarded in view of all the evidence. I think I'll save the last 2.5 minutes that I have. Actually, I want to get this in Millette, it can't be stated better. And I'm going to read the end of the quote that's in the brief. This area is unique, and once it is entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. We have birth, we have life. The actions here impacted this family because of the mistreatment of their father. I'll save the last almost 2 minutes.
You may. Thank you.
Good afternoon, and may it please the court. My name is Doug Tuminello on behalf of the appellees. My bar number is 27523, and with me at council table is my colleague, Abby Harder. I would like to start, if I may, with a couple of the questions that were asked from the bench, because it is clear that it is undisputed that the plaintiffs did not instruct the mortuary not to proceed with the rosary services, despite the fact that they understood that those services were going to occur. What happened was after Miss Olin approached and said, "That is my father there," at that point, Mr. Valero, one of the mortuary employees, looked into the matter, and the mortuary employees acknowledged that there had, in fact, been a mistake and conferred with both of the parties. Now, the representative of the DiCamillo family, who was in charge of the ceremony, made it known that he wanted the rosary to continue forward, and even said that nothing should be said to the assembled crowd. Now, Miss Olin...
Was Ms. Olin made aware of that?
Miss Olin was present for that conversation and said nothing, despite that conversation having occurred. In fact, as of that point, Miss Olin had instructed the mortuary employees on a couple of occasions that she didn't want her mom to know anything about what had happened. And so she ultimately gave some contrary instructions, but she was part of the conversation where that all occurred. And so was her brother. Dom Sansota was also part of those conversations. And those facts are in the record, and those facts are undisputed.
As I read the testimony, though, both Ms. Olin and Mr. Sansota, it seems to me from the testimony that they did not have a lot of time, and they were never asked their preferences. So while they asked Mr. DiCamillo's nephew what he wanted, they themselves were not asked what they wanted to do with their father's body there.
But, Your Honor, I think what's important, though, is that they were part of that same conversation. This was all taking place toward the back, outside of the presence of the assembled crowd, but it was all occurring at the same place. Where the words said to Ms. Sansota, what do you want by way of the rosary? Those words were not asked. But certainly she had the opportunity, as did the rest of the family members, to interpose an objection, which never occurred. And I think that it's important to realize the context of this. And if I may, Judge Marquez, as far as the timing goes, the rosary was to be conducted at 6:30, not at 7 o'clock. And what happened with respect to the timing was during the period of visitation, which began at 4 o'clock, Diane, Mr. DiCamillo's caretaker, at one point came up to one of the mortuary staff and said words to the effect of, "I don't think that looks like Sam or Mr. DiCamillo." What had happened then was a short exchange where the mortuary staff member said, "Well, embalming can change the appearance of the body, etc." She left. She then came back and had the second conversation with the staff member and said, "I talked about my concerns with Mr. DiCamillo's family, and they said nothing was amiss. There were no issues." So this is Mr. DiCamillo's family who was saying there were no issues. So if you look at this from the perspective of the mortuary staff at that point, there was no issue. There were 150 people approximately who were in the visitation in the rosary service at that point. 70% of whom it's undisputed were familiar with both the DiCamillo and the Sansota's families because they were, as you know, they were related. None of them expressed any concerns about the body that was in the casket. So it wasn't until Miss Olin came forward immediately prior to the rosary and said, "That's my father in there." That's the moment that is of importance because that's the moment when staff was on notice and began their investigation. And there's no doubt that when they looked into it, they apologized and they reacted.
Is there anything in the record to indicate that after the caretaker spoke to the mortuary staff that they checked to see if it was the right body?
There's nothing in the record, no, Your Honor. There's not.
Did anybody talk to that mortuary staff person?
At the time of you mean at the time when Diane, the caretaker, first came forward?
Well, I guess by the time you got to court, did anybody talk to him to find out what actually happened?
Yes, Your Honor, and the testimony is that Diane came forward and said, this doesn't look like Sam. they had a conversation about that, about how embalming can change the appearance of the body. And then that was all done in the context of the other family members expressing no concern. Diane having that conversation with other DiCamillo family members and say, there's no issue here. And so that was the context of the conversation. And then shortly after that, when Ms. Olin came forward and expressed what she did, that's when an investigation took place, so to speak, and identified what had happened. So at that point, that was when the mortuary was on notice that a mistake had been made, and then that's what started the chain of events.
Why do you not think they were on notice when the caretaker first brought it to their attention?
Because it was a vague statement, Your Honor, of, gee, this doesn't look like him. And there's testimony both from the mortuary staff and from the plaintiffs themselves who've been to funerals acknowledging that embalming and the funeral process can change the look of the person, of the deceased person. And so it didn't raise to the level of concern or urgency until, of course, Ms. Olin came forward and said what she did. I would like to.
Mr. Tuminello, there's some testimony in the depositions, I believe, in which both Ms. Olin and Mr. Sansota say we weren't given an opportunity to have input into the decision. Is that accurate?
As I said, Your Honor, what the testimony showed is that they were there and part of those conversations, and they had adequate, that was the opportunity to say something, to say.
As I recall, the testimony was, we got to fix this problem, words to that effect. But and I don't think there's any testimony of this, correct me please if I'm wrong, there was no evidence that either Mr. Valero or Mr. Loricella said, here's what we propose to do. Is that okay with you? There was nothing like that, was there?
That's correct.
Okay, so what about that? I mean, the fact that they consulted with the Sansotas, and then they consulted with Mr. DiCamillo, my impression from reading the depositions is that they immediately then went, Mr. Valero immediately entered back into the sanctuary, approached the casket, closed it, took the flowers off, took the flag off. And there was no further conversation. Is that accurate?
I think that's accurate, Your Honor.
Okay.
I do think that that's accurate.
So when they say we weren't given a chance to be consulted about it, in other words, after Mr. DiCamillo's nephew says, let's proceed, would that be an accurate inference that could be made?
I think that they all happened in short order. I don't know if I can, I don't know how short that order was, but.
But is it an inference that one could draw? Is it a reasonable inference?
There's no
I mean, that's what we're
testimony at
supposed
that point,
to
Your Honor.
decide. You're supposed to say all the inferences are in favor of the plaintiffs, right?
Right.
So I'm trying to discern if that's an inference that could be raised in plaintiff's favor.
Well, I think that there are probably any number of things that the plaintiffs would say they could have done, or what they would have preferred to have occurred, and that was certainly one that they argue. But I think that when they were at the beginning of the rosary that was being delayed with the assembled crowds, and the staff was talking to two different families, and they made the decision to close the casket, remove the flag, et cetera, and to go forward with the rosary. That is, in fact, what occurred. But I think at that point, Your Honor, then the question is, did that act, did that rise to the level of outrageous conduct? And Mr. Vernesic asked the somewhat rhetorical question of what is outrageous conduct, and it's not as freewheeling as he would have this court decide. In fact, the case law is pretty well developed in this area, and I'll start by reading the characterization of outrageous conduct from Churchy v. Adolph Coors. But it's that conduct which is so outrageous in character and so extreme in degree as to go beyond all bounds of decency and to be regarded as atrocious, utterly intolerable in a civilized community. It's one in which the recitation of the facts to an average member of the community would arouse his resentment and lead him to exclaim outrageous. And of course, it's the court's purview to act as the gatekeeper on whether or not conduct is considered outrageous. There is a history of these types of cases in Colorado, none of which have found outrageous conduct, but I think that it's instructive to know what the court has said about outrageous conduct. So in, for example, the Coors Brewing case at 978 P. 2nd 663, and this is a Colorado Supreme Court case, there in which the defendants scapegoated the plaintiff to cover up the defendant's own criminal action, that was considered not outrageous. In English v. Griffith, a Court of Appeals case from 2004, 99 P. 3rd at 90, the defendant's continuation of an argument with a cohabitant that he knew to be suicidal and who then went on to commit suicide, not outrageous. In Regal v. Sava Senior Care, 292 P. 3rd, 997, this is another Court of Appeals case from 2011. The defendant's actions toward a decedent in a nursing home, making caustic comments, gaslighting the plaintiff, making them think that they're crazy, failing to transfer the patient to the hospital, though being characterized as abrupt, irresponsible, and lacking in sensitivity, held not to be extreme or outrageous. And so whether conduct is extreme and outrageous is a extremely high bar. And the question that the trial court appropriately answered is whether this conduct of allowing the rosary to go forward in the light of these facts, whether that was outrageous, and the court got it right. Now, Mr. Vernesic was correct. There are no disputed issues of material fact in this case. The issues, or the facts, are well laid out. And really, the court answered the question, the two questions correctly. Did the defendants act intentionally or recklessly toward the plaintiffs? And did what occur amount to outrageous conduct? The court looked at both of those questions and got both of those answers right. There were no undisputed facts. There was no evidence of intent, and there was no evidence even of knowledge on behalf of the defendants until Ms. Olin came forward and said what she said. That's my father in the casket. It's not Mr. DiCamillo. And so at that point, the defendants could not have acted with the requisite intent up before that point. And then after that point, there was simply no evidence in the record that the defendant's conduct toward the plaintiff was intentional. In other words, intending to cause severe emotional distress, nor was it reckless. In other words, undertaking with the knowledge that there was a substantial probability that what was going to happen would cause severe emotional distress.
Can I ask you a question about that, Mr. Tuminello? At the time Mr. Valero left to go up and close the casket, he had witnessed Ms. Olin's distress, had he not?
I don't recall there being any testimony that one way or the other, but I think it's safe to assume they probably had.
And as I understand it, she said we need to fix this problem. According to her deposition testimony, she said she was weeping at the time. So you don't have anything to contradict that, I assume.
She was saying, what are you going to do to fix this,
Okay.
in essence.
And so when the decision is made to simply proceed with the rosary, without further consultation with her or with her brother, is that indication that there's some possibility of recklessness because they knew at least one person was experiencing emotional distress?
No, I don't think so, Your Honor, because we also have to look at this in light of the conflicting instructions that Ms. Olin had been giving at that time, instructions to the effect of, my mom can't know that anything has happened. She can't know she can't have known, or she can't know about what's going on here. And so the mortuary staff was having to consider that. They were having to consider their conversations with the DiCamillo and the Sansodas family.
What about simply removing the casket?
Well, Your Honor, I think that that's certainly what the plaintiffs said they would have preferred to have happened. But there are any number of permutations that we can look at as things that might have done or might have happened differently. But I think that you have to look at it you have to look at it in the context of what the defendants actually did based on the knowledge that they had at that particular moment, and they acted reasonably.
Thank you, Mr. Tuminello.
I think the facts are disputed. Number one, the issue before the court is the disputed issue of fact. Is it outrageous conduct? That's just right out of Culpeper.
Well, that's the legal conclusion, Mr. Vranicek. I don't know that just the question being raised is the issue of fact.
But it says in Culpeper that whether or not it rises to outrageous conduct itself is the issue of fact that has to be decided.
Well, it's for the court, though, to decide the issue initially. You don't
Initially,
dispute that.
that's true. That's
And
why I said,
the court has to make sure the facts are undisputed,
yes,
and then say, from these undisputed facts, could a member of the community, reasonable persons differ in their discussion about it?
that's absolutely correct.
Okay, thank you.
With regard to the discussion with Diane, she didn't come up the second time and tell him that she talked to the family. That was another discussion if you go read the record. She came back the second time saying, that's not Sam in there. And that's the caretaker. And then we say, what was the notice? Gary Laricella, after the first time, was already on the phone to TJ Valero, telling him, get down here, we got a problem. What's really interesting is TJ Valero gets there and immediately goes up to Mrs. Olin and says, yep, you're right, that's your father in there. Without any other investigation facts, how does he know that? Lastly, the conversation with the nephew. That occurred at near the chapel doors. They didn't hear any of that conversation. That's when he went in, removed the flowers, the flag, closed the casket, and he went out a different way. He didn't come back by their way. They did not give the permission to hold that rosary. Thank you.
Thank you. Thank you, counsel, both counsel, for your very helpful arguments today. The case will stand submitted. An opinion will issue in due course. That concludes our 1:30 docket and the remaining docket for today. Court will be in recess, and bailiff, you may so announce.